Kumarji Jaurepati, President of today's function, Sri Mhase, Secretary of the Ahmednagar Jilla Maratha Vidya Prasarak Samaj, Sri Professor Suresh Mishra, the President of the Consumer NGOs in Ahmednagar district, and other respectable members on the dais, the professors who are participating in the seminar from the other states, today's subject is touching the everyone, not in the state of Maharashtra, but every citizen in the country. Everyone is a consumer, that is already stated. The whole object of the Consumer Protection Act is to see that the consumer is a king in the market. The very thing that is a desired object of the act shows that somehow or other the legislatures in this country have already felt that he is not in that position which is expected by them. Organized traders, organized manufacturers with the companies which are coming from the outside the country. They enter into markets, supply the goods, and if it is a defective good or the service is a deficient one, there are several ways to defeat the right of the consumer. Especially the foreign manufacturers who entered into this country, they give the agencies to the different firms and the traders in this country. But whenever question comes about the consumer right, they simply say that we are not responsible. Who is responsible according to them? That the person who sold the goods to you, and he is not a manufacturer of the goods. He says that these are the goods manufactured by so and so company. I have taken it from them and sold you. So if there is any defect in the goods, the company is responsible. I am only a trader, seller. And to defeat the rights or to avoid the responsibility, they have developed a principle under a contract act a principal to principal liability. That means the trader here is not an agent, not a franchisee. But he is equally a principal. And thereby this is the principal to principal liability, and we are not strong. The Supreme Court has accepted this principle. But in order to cover all these companies, appropriate provisions are required to be incorporated in the Act. There are very simple things. What I feel that one of my friends, you see that whenever there is no change with the trader, 1 rupee, 2 rupees, he gives you chocolate. And if you say that I don't want a chocolate, then he says that you pay me in change. And you don't have. Naturally what happens? You accept the chocolate, chew it. He earns. Even though you do not want it to purchase, you have to purchase. You are a loser. But one of my friends, who is also advocate, when he was visiting the canteen, he was given the chocolates, and he instead of chewing the chocolates, he collected it. And one day he collected the 50-60 chocolates with him. He consumed whatever he has to consume in the canteen. And then place these chocolates before him, because you paid me this. This is a value. 1 rupee I had, you don't have a change, therefore. But how many consumers will do this? In fact, it is a principle under consumer law that the trader should return the amount which is to be returned. And he cannot enforce for saying that you should accept a chocolate or some other alternative goods in lieu of the want of change. But this is a very small issue. Whether for this small issue, a consumer will go to the court or to the agency. But then nobody makes a grievance about it. Now you see that every day you go in the market, in the morning, purchase a small bag packed milk. There is a printed price on that packet, but he charges you 1 rupee more. Especially in Bombay, I have observed it. And ground for what? Why 1 rupee? He says that is the freezing charges. I have to keep in the freeze whole day, and therefore the freezing charges you have to pay. But in fact, this is not a requirement. The price which is quoted on the bag is inclusive of all taxes and everything, and therefore the extra freezing charges are not required to be paid. But how many from us who pay this amount are making grievance? No one is making grievance. When I was visited the Kolhapur, one lady came to me with a grievance that I purchased the gram this mall. It's a half kg. When she went home, she found that it is infected one, not in good condition. She returned to the mall, showed him that this is article which you supplied me. He said, not in good condition. They said that you sit here. She was asked to sit for 1 hour. And then she was told, Madam, we could have exchanged your bag, but you have opened it. Now it is not possible. And she was making demands for this. What should I do for this? I said that you should have come to the consumer forum. The problem is, for 10 rupees small purchase of a half a kg goods, whether a consumer will come to the consumer forum by following the machinery. I am giving these examples because lot of consumer rights are every day and every minute are violated by this traders community and the manufacturers. And they have an organized sector for that purpose. And against them the whole machinery has been provided in the Consumer Protection Act. But the very few know. Therefore, the one suggestion or one thing which we have to consider, that now is that the district forum located in Ahmednagar, man from the Akola has to file a complaint here. And whether a complaint will be disposed of within one day? No. It will be disposed of after a, though law expects it to be disposed of within a certain period, it is never disposed of like that. Years together the complaints are pending. Therefore, I desire that, because I stand for, because after having looked into these matters and being a president for this for 3-4 years, I am in favor of a speedy disposal of the cases. The cases should be disposed of as early as possible, because this is a new jurisprudence, different jurisprudence than because no doubt the reference has been made to the Donga versus Stevenson, a case decided long back under a tort. But now Consumer Protection Act is not a simplicity dealing with the cases under the torts and the negligence under the torts, but it decides the cases under the contract, warranty, so many other sale of goods. If you have foreign transactions, the foreign covenants are required to be looked into. Therefore, the scope of the present Consumer Act is a very different than what we have done in a Donga versus Stevenson. But we have to consider that how to have a mechanism, and this seminar will discuss it and will try to find out the solution. Because when I took the charge in State Commission of Maharashtra, in 2009, I found that the cases instituted in 2093 are pending. Now, a consumer, if the appeal is filed in 93, and it is not decided till 2009, what is the difference between the consumer forum and the civil court? We developed this quasi-judicial authority Consumer Fora is not a complete judicial authority, it is a quasi-judicial authority. But object of this quasi-judicial authority was, to provide this machinery was, to have a speedy disposal of the cases with an experienced person at the head. Because therefore the district judge is made head of the district forum. High Court judges are made a president of the president. Supreme Court judges are made the National Commission's president. After the sitting judge or the retired judge. But an experienced man in the judicial field. Has been provided by the legislature for a speedy disposal of the cases. The result is the cases are pending for years together. And therefore we will have to find out where the fault lies. Whether the legislation is defective or whether the persons who handle the machinery are responsible for the delays. It's a matter to be looked into. And this seminar, I think, will discuss this issue thoroughly, because unless you provide, because you see that I have experience in Hingoli, I have seen 9 cases were there. 9 cases can be disposed. 9 cases, 1 forum, 3 persons sitting there for 2 months, 1 week. But within 1 week, 9 cases cannot be disposed of. And years together the cases are pulled out. And what are the cases? In Bombay we have cases like builders cases. Much more cases of the builders. But the other cases, very small issues are there, admitted facts are there. Because nobody disputes that he is not my consumer. He has not purchased the goods from me. But the hyper-technicalities. And please, I will request the persons who have a faith and belief in civil procedure code shall not be brought as a president of the district. A dynamic person with a legal background and who knows what is the difference between the judicial process and the quasi-judicial authority shall be there. And I don't hesitate to tell you that in some of the interviews I have asked retired district judges, how do you distinguish between the judicial process and the quasi-judicial procedure? And unfortunately not able to explain it. This has reason because these persons, since they were conducting the suits, they were conducting the appeals, etc., under the civil procedure code. They follow the same procedure for disposing of the complaints, which is not expected under the law. Law has provided that civil procedure will apply to the extent stated in the section, and only summons to be issued, evidence to be recorded by affidavit, like this, commissions to be appointed for verifying the particular purpose. Whole of the civil procedure code is not made applicable, but we follow the same. If the persons come from the city civil court, he follows the procedure of a city civil court. If the persons come from the district judge, he follows the CPC. Result is not because the advocates want it. A protraction of the case is always one of the game in the advocacy. Therefore, they want it that this procedure should be followed, dates of the date should be given, right? But the shortened procedure which has been provided in the statute, that has to be followed. And for that purpose there should be insistence. That is not being done. If this procedure is still, I don't say that this is all complete procedure. We may have a still better procedure, a shorter procedure than this, which is provided in the present statutes or in the coming statute.